Hello and welcome back. Today we will be discussing family petition. Form I-360, officially called the Petition for Alien Relative, establishes that a valid family relationship exists between a U.S. citizen or a green card holder and a person seeking a green card. This form is often simply referred to as the I-130 petition. Filing the I-130 petition with the U.S. Citizen and Immigration Services USCIS, which is part of the U.S. Department of Homeland Security, is the first step in the family-based green card process. Not sure if you qualify for a family-based green card? Start by checking your eligibility. In the context of the marriage visa, the I-130 petition is filed to prove that your marriage is legally valid based on a marriage certificate. This is also the phase of the marriage-based green card process in which you submit in documents, for example, a joint bank account statement, joint insurance documents, and photos together to prove that your marriage is authentic, that is, it isn't based on a fraud. Filing the I-130 petition also establishes your place in the line for an available green card, unless you are the spouse, parent, or unmarried child under age of 21 of a U.S. citizen who gets to skip the line entirely. Your place in the line is determined by your priority date, which is simply the date that USCIS receives your I-130 petition. Typically, petitions are processed in order they are filed. Check out the Visa Bulletin to learn more about the current wait time for specific green card categories. Who can file Form I-130? U.S. citizens can file I-130 petitions for their spouses, children, parents, and siblings. Current green card holders can file I-130 petitions for their spouses and unmarried children. The U.S. citizen or green card holder who files the I-130 petitions is officially called the petitioner or a sponsor. The person seeking a green card is officially known as the beneficiary. Who cannot file Form I-130? There are some eligibility exclusions that prevent the filing of an I-130 petition even when the above family relationships exist. You cannot file an I-130 in order to sponsor any of the following relatives: a grandparent, grandchild, nephew, niece, uncle, aunt, cousin, or parent-in-law, an adoptive parent or adopted child if the child was adopted after he or she turned 16 years old, a biological parent if you became a green card holder or obtained a U.S. citizenship through adoption, a step-parent or stepchild if the marriage that created the step relationship happened after the child turned 18 years old, a spouse if you and your spouse were not both physically present at the marriage ceremony, a spouse if you became a green card holder through a prior marriage to a U.S. citizen or a green card holder, unless you are now a naturalized U.S. citizen or have been a green card holder for at least 5 years. A spouse if you married your spouse while he or she was part of any immigration court proceedings, that means a hearing in an immigration court for someone facing deportation or more formally, removal. Any relative if USCIS has determined that this person attempted to marry purely for immigration purposes. It's important to know that there are exceptions to some of the above exclusion and that you may be able to file an I-130 petition with additional supporting documentation in those situations. The I-130 petition must be filed with supporting documents to prove that the sponsor is allowed to file an I-130 and that they have a valid family relationship with the person seeking a green card. The required supporting documents for an I-130 petition typically include proof of the sponsors is a U.S. citizen or green card holder, proof that a legally valid relationship exists, proof that the relationship is not fraudulent, proof of a name changes for the sponsor and/or the person seeking a green card, if any, proof of nationality of a person seeking a green card. Supporting documents required for a family-based green card include, for instance, a copy of the sponsor's U.S. birth certificate to prove that they are a U.S. citizen. If you don't have all of the documents on hand, don't worry about that. The good news is that you can get on your application now while you gather your supporting documents. You don't need every document to start making a process. The sooner you get started on an I-130 application, the better for you. With Citizen Concierge, all the required forms mentioned turn into simple questions you can answer in under 2 hours. Get started today.